We are Legally Sis. Welcome to our podcast.
The information provided in the show is for general informational purposes only and should not be construed as legal advice on any subject matter. No attorney-client relationship is created between you and Duran and Duran Schultz Law.
Hi, welcome to Legal Assist. I'm Attorney Wen.
And I'm Attorney March. Welcome to our podcast. In this episode, we will be discussing small claims. So, Attorney Wendy, considering that we will be discussing small claims and this is a litigation, can you please walk us through what small claims is?
Small claims is a civil action in nature whereby this is particularly for the claiming of a reimbursement of monetary claims by the plaintiff.
So, what are the restrictions for one to be able to fall under small claims?
Right? This is usually below 1 million pesos in order to be able to be covered within the jurisdiction of this court.
You mean 1 million, like the amount of damages or amount of loan or amount that you want to be collected?
For small claims, the amount is usually does not exceed 1 million pesos. It could either be from or by reason of a contract of loan, contract of services, or those covered by the Barangay Settlement which does not exceed 1 million pesos.
So you mentioned about Barangay Settlement. Before you can approach the small claims court, you will need to undergo barangay.
Well, it really depends because the cases that are covered by the barangay, these are jurisdictional, whereby the parties must be a resident of the same barangay or adjoining barangays. But if the parties are living of the separate or different cities, well, it's not covered by the barangay anymore. But if there is a barangay conciliation and that there is an agreement that has been crafted before the barangay, it could be enforced via small claims provided that the amount does not exceed 1 million pesos.
So if you're ready to file a small claims before the courts, what do you need to do?
There is a pro forma form which has been given by the Supreme Court. This is the statement of claims which could be easily downloadable before the Supreme Court website. And together with that form, wherein you just tick or fill up the information provided therein, you need also to attach a verification of and certification of non-forum shopping, wherein this is you will attest that you are the plaintiff of the case and the case has been filed not to harass the other party and you have a claim, a definite claim against the person that you are suing. Also that you did not file any other cases before that court.
So how do you prove that you have a claim?
You can prove this by attaching certain documents regarding your claim, such as whenever if it is by reason of a contract of loan, then attach a copy of the agreement or the loan agreement, or if it is in other forms like text messages, promissory note, or email, then you can attach that. Also, to prove that is any other forms like the demand letter saying that, okay, you have a loan and you need to pay me with this amount in this particular date. That is also one of the documents that you can present to the court.
So is it really necessary for one to have a demand letter before you go through the small claims?
Yes, it's usually necessary for you to demand first before you go to the court. Of course, how would you know if the loan is already due and demandable if you're not demanding?
So if you have already filled in the complaint and then you filed it with courts, right? What's next?
Okay, as soon as you file the statement of the claims together with the other documents or documentary evidence that you have, the court will prepare a summon wherein the other party will be required to attend and appear before that court on a specific date of hearing. So as soon as the court receives a copy of your statement of claim together with the other documentary evidence that you have, the court will prepare a notice indicating the date of the hearing and the place of the hearing. And then it will be served upon the other party or the respondent that you are suing. And then the parties will be required to appear on that date of hearing. Usually for small claims, this is only 1 day hearing. But courts usually encourages the parties to enter into amicable settlement.
So just 1 day, that means going through the small claims court would expedite.
That is actually the purpose of these small claims, in order for the cases to be expedited and for the parties not to have or incur any other expenses like lawyers, because in small claims actually lawyers are prohibited from appearing therein, not unless if the party himself is a lawyer.
How long do you think a small claims case would be finished?
Usually it's just a 1 day hearing. So if the judge will set the hearing and then the parties are present, and then the court can actually decide right then and there, or usually given a 24 hours within which to decide the case.
Oh, well, that's great because that will already expedite and make things easier or faster. And then once you have the decision, how can you enforce it?
Well, you enforce it like the regular proceedings. It is via the help or the assistance of the sheriff. So that's a different process.
So what if you can't find the respondent? The one that, for example, asked or borrowed money from you. What is your option?
In such cases, well, the party can actually ask the court to have the summons published in a newspaper of general circulation if the other party cannot be served with summons.
Yeah, generally, they don't want to appear if they know that they are on the losing end.
You file the small claims at the residence, or either the residence of the plaintiff or at the residence of the defendant.
For the purposes of our viewers, the plaintiff means the complainant.
Yes, and the respondent is the one being sued. But for purposes of lending corporations, it is usually at the place of the defendant.
So what if the defendant will not appear in court? He was invited, he received the summonses, but did not purposely appear at the date and time indicated by the court.
Well, by that instance, the court will render judgment based on the complaint of the plaintiff himself. Because remember, the court has already given the other party the opportunity to respond, but he just did not choose not to respond at all.
Yeah, those people that find themselves being sued before the small claims court, it is necessary for you to appear because it's like a waiver of your rights. You can't defend yourself if you don't appear.
Yes, and remember, in cases of small claims, whenever there is already a decision by the court, it's not appealable.
So, Attorney Wendy, if the plaintiff or the complainant is not available or cannot file personally, is there an alternative for that person to be able to file the small claims?
Well, generally, it must be the plaintiff himself who will file. But if in cases that he or she cannot represent himself, either by reason of he's outside the country, then he can file through a representative as long as he or she has a special power of attorney. But remember, the representative must be of next of kin, and it must not be a lawyer.
Right. So I remember in one of the small claims that we have assisted, not appeared because that's absolutely not allowed, but when it comes to documentation wise, the court is very strict in asking that the documents attached to the complaint are all originals or certified true copy.
And it must be complete. If you have a affidavit of your witnesses, it must be attached, because during the proceedings, no other evidence can be presented if it is not included in the small claims complaint.
I remember there is this foreigner that approached us because he was a lessee to a condominium unit here in VGC. And upon the end of his lease agreement, of course, he already turned over the property to the lessor. But unfortunately, his security deposit was not returned to him. And the option that we've given him was to file a small claims.
Yes, because under the small claims, remember this is for the payment of monetary obligation or the refund, which could be emanated from a contract of lease. That's one.
Yeah, unfortunately, in that situation, it was not successful for a number of reasons. The first one is he was really too busy and he couldn't appear before the court.
Yeah.
When there's a hearing, of course, if you have an executive, a president of a corporation, and you are at the mercy of the court schedule. Oh yeah, I remember one of the reasons also was during COVID time.
COVID time, yes.
Yeah, and he was traveling and it was very difficult for him to come to the Philippines. So unfortunately, despite several resetting, the court was really understanding because he has shown proof that he cannot travel. But eventually, after 3 hearings that you cannot attend to, then it would have to be dismissed. Okay, Attorney Wendy, before we end, could you please give us examples of actions that may fall under small claims?
So usually for the small claims, as I mentioned earlier, these are for the recovery of the payment of monetary claims, either under the contract of lease, contract of services, or contract of loan or other accommodations, and contract of sale of personal properties. So
If you want to have something recovered, even though the value of the property is less than 1 million.
that's excluded under this small claims.
All right. Thank you, Attorney Wendy.
Bye.
Bye.